Welcome to Lawline with your host, the distinguished New York lawyer, author, and lecturer, Alan Schneerman. Each week, Lawline will bring to you the most knowledgeable experts in the field of law today. And now we introduce today's guest and our host, Alan Schneerman.
Welcome to Lawline. Recently I read an article in New York Magazine entitled Women and Divorce, and felt that some of the issues raised in the story should be explored further. Today we have the author of this controversial article, Catherine Boughton, as our guest. Joining in our discussions we have Leonard Marlowe, the Director of Legal Services at Divorce Mediation Professionals, and Steve Gassman, a prominent matrimonial attorney with 16 years experience. Welcome.
Welcome.
Catherine, the day after your article first appeared in New York Magazine, I remember I walked into my office and everybody was talking about it. What kind of response did you get?
I also got a lot of response, more to this article than to anything I've written before. I think most of my mail was from people who recognized stories as being similar to their own, and I think that nobody had really written about the impact of this law since it was passed 4 years ago until now.
Well, I know in my office, everybody was either for it or against it. Nobody was sitting on the fence. And of course, it's full of lawyers. Is that what you experienced as well?
People who write to the author are usually for it. People who write to the magazine are usually against it, hoping that their opinions will be published. Almost all the mail I got was favorable, saying thank you for telling my story, and is there any way that my own story can also be published? A lot of people felt that this was a way to get whatever recompense they weren't able to get through the law courts, was to have their stories told.
And of course, by this new law, you mean equitable distribution.
Yes, which was passed in July of 1980.
Well, that's here in New York. But of
New
course,
York,
equitable distribution has been quite some time in New Jersey.
11 years, I think, in New Jersey.
Okay, which brings me to Steve. Steve, what is equitable distribution?
Equitable distribution is a form of property distribution upon divorce. What it means is that property that is acquired during the marriage, with certain exceptions, can be distributed equitably. That doesn't necessarily mean 50-50 as in a community property state, but it can be distributed equitably regardless of whose name it's in. It no longer matters if it's in his name, her name, or joint names. With equitable distribution comes the concept in New York, for the first time really, of what's known in other states as rehabilitative maintenance, which is the idea is if there can be a more just property division, there will not be this need and reliance upon perpetual maintenance, and hopefully there can be a definitive period. Now that doesn't work in all cases, and that's one of the problems of equitable distribution right now. But that's it in sort of nutshell form.
Let's explore that by the word rehabilitative maintenance. It sounds like a fancy word, but are we talking about that maintenance will be for a specified period of time as opposed to the life of the spouse?
Well, the law says that it can be for a definite or indefinite period of time, and the judge has discretion in a given case to rule either way. If we make it for an indefinite period of time, we generally mean until death of either of the parties or the remarriage of the so-called payee spouse, the recipient spouse. Otherwise, a court can fix a definitive period. It could be 5 years, 10 years, depending upon a myriad of factors, in which it would be assumed at that point that with the property distribution and with the background, the education, and necessary training of the recipient spouse, there would no longer be this need for payment by the other spouse. Okay. And of course, all of these things are now gender neutral. It works both ways.
And of course, Steve, you're an attorney and you represent either the husband or the wife. Would that be correct?
Correct.
Now, Leonard, you're an attorney, and am I correct to say you represent neither the husband or the wife?
Neither of the parties.
Okay,
in mediation.
But you are a mediator. Tell us what mediation is.
Mediation is simply an attempt in a non-adversarial atmosphere to assist a couple who is separating and divorcing and concluding an agreement. You get to the same place, you just use a different route. Instead of each of the parties hiring attorneys who are going to be advocates for them, they sit, and as you know, our system is an adversarial system. That's how the system works. They sit down in a non-adversarial atmosphere and attempt one by one to deal with what are really practical issues in their lives.
But how long has this been going on for, the mediation?
Well, mediation has been going on a long time. In this country, probably about 12 years. Actually, in the last 4 or 5 years with any degree of emphasis. It's now practiced from one end of the country to the other, as you probably know.
Catherine, after reading your article, I got the impression that you felt that women did not fare well under equitable distribution.
That's true.
And can you tell us why you felt that? And what research, what did you find that brought that out to you?
Well, mostly talking to women and men who had been divorced. I interviewed men as well as women, and the men as well as the women felt that they hadn't fared well under equitable distribution. In fact, I came out of the research feeling that nobody fares well in divorce under any circumstances. But my feeling about women is that the courts did not seem to be taking into consideration the kinds of women who are being divorced now and the kinds of marriages that they entered 20 or 30 years ago and the expectations that they had at the time they got married. Those seem to be the women from long-term marriages who seem to be suffering the most, I think.
Okay, Steve, you're out there on the battlefield every day. What do you think?
Well, I agree with Kathy to the extent that divorce by necessity is failed expectations. But from a point of view of equitable distribution, I think it's far superior to what we had prior to July 1980. When we were just a title state, whoever had a title to the specific property would retain it. In most cases, this became the moneyed spouses, which in the traditional family unit at least, and this is changing, was the husband. And the wife would be left very often with no property. And even under the old law, even if she was guilty of some indiscretion, which rose to the level of marital misconduct, she could be have her alimony forfeited forever. So there were enormous inequities under the old law, and there are some under the new law. But I think it's far better than what we had.
You say it's far better. However, when I read the article, and when I read the interviews that Catherine did, it seemed one after the other, the women said, no, I'm faring less than I would under the old law. As a practical aspect, here's a woman who says, I'm not getting what I should be getting. You can tell me from today to tomorrow that I'll do terrific under the new law, but here it is 4 years later, 3 years later, I have less to eat. The standard of living has dramatically changed for me. Before I lived in a beautiful house, now I'm living in a small apartment with my children. What do you say to her?
All right, Alan, you have to look at equitable distribution from the effect it's had upon different people. For the wealthy, it's eminently fairer. There are no great problems. I think most lawyers and people who work in the battlefield, so to speak, every day would agree upon that. The problem we're having, and I think it's starting to be cured, is that where there is not sufficient property involved, which if you gave a spouse 50% of it, for example, would make him or her financially independent, there is a quickness to take away the maintenance, the necessary maintenance, which of course is the new terminology for alimony, I think too quickly. But I think that message is getting across, and we're starting to see more and more cases where maintenance is being awarded for a longer period of time, and in many cases an indefinite period of time, which means, as I said, until death or remarriage.
Leonard, what do you think? I see you jumping to talk.
I think the problem you have to realize is that the legislature can rewrite the law as many times as it wants. It doesn't change the size of the pie. And the problem under the new law is that many people feel that what was granted in equitable distribution did not compensate for what was taken away in maintenance. And you have to be careful in terms of who you speak to here. Most people have as their principal asset their home. And even under the old law, the home was generally in joint name. So even though it was a title state, still that home was divided 50-50. The problem is that for the large group of people whose major asset is the home, where the wife would have gotten 50% even under the old law, there is not enough additional assets to make up, in terms of equitable distribution, for now what Steve has correctly indicated is the court's tendency to, I think, too quickly cut off on the issue of maintenance. There's another problem, that when you're talking about the division of assets that is money in the bank, the court is more inclined to divide that 50-50. But when you talk about assets that involve individual effort, like a man's practice, and in most instances that is the extra. In other words, the extra is that he owns a business or he has a practice. The courts are less inclined to treat that like money in the bank and make a 50-50 distribution. So even for wealthy women, they can end up getting only a small portion of those marital assets, which may not offset what they get in equitable distribution. The one thing that you must keep in mind, though, that makes equitable distribution very fair, is that under the old law, if they gave her support forever, saying, I'm not going to give you an interest in your husband's business, but it doesn't make any difference because he's going to support you forever, if she remarried, she lost that. If he remarried, he still kept his business. Here, at least, what she gets in equitable distribution, she keeps forever.
Catherine?
Sorry, but what we're not discussing is what used to be called alimony, which is now called rehabilitative maintenance, which is the money that a husband pays in support, either child support or child and wife support, I guess you could call it. Except, of course, this is also true if the wife has the money, that she would be paying support to the husband, so this does work both ways. What's happening under equitable distribution that I found is that joint property is being split evenly, but the courts are not awarding women who do not have experience in the business place and who don't have a way of supporting themselves sufficient money to live on themselves and to raise their often infant children. Judges are telling these women that they, within 2 or 3 years, should be self-supporting, should be getting jobs. And that's not always a possibility.
Leonard, I'd like to get back to that question. As a practical matter, in an everyday situation, now you practiced under the old law, and now you're a mediator under the new law. What do you find? Do you find that the old law was better, the new law is better?
See, I think it depends upon which class of people you're talking about. I'm concerned also about limited maintenance.
Let's take it
frankly.
step by step. Let's take the middle class, which is most of our viewing audience.
But you see, for the middle class, I think that the woman can come out on less favorably than she did under the old law, because if they're not substantial assets, she would have gotten half of the house in any event under the old law. So now there aren't sufficient assets to make up for the fact that the court is awarding limited support. And I'm frankly shocked at how short some of the awards are in even marriages of long duration. Steve may be right in saying that, and this may happen in time, that the courts will take a second look at this. But my initial reaction was that they were attacking more vigorously the limited maintenance than they were attacking the problem of equitable distribution.
Leonard, can I ask you to take us into the mediation room? What happens there when the parties first come before you? What questions do you ask? What questions do they ask? And then what do you do?
Well, the first thing that happens is that you attempt to establish a rapport with the couple. In mediation, most of what happens is on the basis of the context that's created. We usually meet and sit around a round table, and the whole atmosphere is designed to convey to the couple that this is a very difficult, stressful period for them. We know that it's difficult even for them to be in the same room, but there is a common problem here that we want to solve, and more importantly, it's really a practical problem. We're talking about their children, we're talking about their home, we're talking about those kinds of substantive issues. We also try to convey to them the fact that they are going to have an ongoing relationship. Mediation was born of a concern for how families were left after they were finished with an adversarial process, and also born in the realization that for the benefit of their children, they have to be assisted to deal with these practical issues in a way that when they get through, they can still maintain the necessary relationship. Their divorce may end their marriage, it doesn't end their family. And the whole tone and context of the discussion is one that's designed to emphasize what we call their commonality. Lawyers protect people's conflicting interests. Mediation points out that they also have interests in common.
Well, have there been any statistics on your success rate?
Well, when you say my success rate of mediation generally...
Mediation, I'm not talking about you personally.
It's too early to say. I'd be kidding you if I told you, mediation's only been around for a very short period of time, and to suggest to you that there have been national studies that have indicated the rate of success, I couldn't tell you that. You ought to know this, that to a certain extent, it's probably a self-select system, in the sense that people who come to mediation are more interested in getting on with their lives than getting even. If someone is anxious to get even, he's not going to do it in mediation. So we probably deal with a group of people who, by definition, have a very strong motive to find a way to resolve this if they can.
Leonard, I know my viewing audience is very concerned about costs. How much does the legal mediation...
It depends. The way mediation works is that very often you will go to a mediator who will charge you on a time basis per session, and then when you get through, you're left with what's called a memorandum of understanding that you then take to an attorney, and he prepares an agreement.
How much, Leonard?
I can't
Approximately.
I think for the average person, you're probably talking somewhere between $1,500 and $3,000.
All right, so at least they have a range which they can budget.
Yes, for the average couple.
Now let me go over to Steve. Steve, what happens at your first interview with a new client?
All right, well, obviously, we're part of what's described as an adversary system, but designed to protect the interests of one individual. We're not acting as a mediator. Although, let me point out that lawyers in New Jersey and New York, and studies have shown this, settle over 95% of the cases. Less than 5% are actually tried on a contested basis before a court.
Prior to verdict?
Exactly. As concerns mediation, here's where Len and I somewhat part company, I believe, in our views, because I believe it favors the strong at the expense of the weak. The more moneyed spouse, the more knowledgeable spouse has an inherent advantage. To do justice and to do right and equitable distribution, you must undergo the processes of discovery and valuation. Time and time again, one spouse will have a business in which he or she claims it's worth a nominal amount, when in reality, after you've gotten all the information, you've used appraisers and accountants, you find out it's worth a considerable amount of money. That's part of the marital property. That's part of the property that's divided upon a divorce. You cannot do justice to people without knowing these basic facts. And in my judgment, it's through lawyers and the traditional process that these facts are ascertained. There's often an attempt to hide them. We all know those stories. But this has to be ascertained in order for justice to be done.
Steve, how much does a divorce cost nowadays?
Fluctuates enormously. If you're talking about not the purely uncontested divorce,
No, I'm
where
not
issues
talking
of
about
property
that.
involved,
I'm talking about the couple that has a house on Long Island or in New Jersey.
the general range could be anywhere from, let's say, $3,500 to $15,000, and there are cases, obviously, that go higher and lower.
Well, let me ask you this. Is one spouse, the non-earning spouse, entitled to be reimbursed for any of these fees?
That's discretionary with the court. And that also depends on the final outcome. The trend is, where there is substantial property involved and the court is making an equal or almost equal distribution, the trend is more towards letting each spouse pay their own fees because they have a fair share of the property with which to do it. But where that's not the case, a dependent spouse can still get an award of counsel fees. As not only counsel fees, but appraisal fees, actuarial fees, things of that nature. Which is another thing which the judicial system takes into account. Pensions are an enormously important asset in equitable distribution.
Let me just ask one more question of you, Steve, if I may. What about the spouse who is the non-earning spouse, who has no control over the checkbook, who has no control over the assets, who does not have family that they could fall back on to ask to pay for a lawyer? What does that spouse do?
That spouse can retain a lawyer or make an application to the court for an award of counsel fees to be retained.
Well,
In other words, you can get a temporary
what
award of
comes
counsel
first?
fees.
I would assume you have to
Well,
retain
you
the lawyer
can,
next to the application.
but the lawyer can make an application for a temporary award of fees, and if the other spouse has the money, that can be done.
Thank you, Steve. Catherine, talking about court now. I know in your article you discussed a survey that was brought out by the New Jersey Supreme Court regarding bias in women. Can you discuss that?
Yes, this was a study that was undertaken by 31 judges, lawyers, and educators in the state of New Jersey to see whether there was gender discrimination in the court system in New Jersey. It dealt with, in addition to matrimonial law, things like kinds of awards made in personal injury cases. Matrimonial law took up one of the largest parts because they felt that was where women really suffered the most. And it found, this study found that women were being awarded, for instance, on an average, only 30% of joint marital assets, things that were owned in common. The husband was getting 70% and the wife was getting 30% for herself and the children. And that maintenance awards averaged between 35 and 40% of the husband's salary, which leaves him 60 to whatever it is. I'm not very good with arithmetic. And maintenance is also tax deductible to the husband, so that this was pre-tax figures that we're talking about.
And I assume tax includable by the wife, if that's the case. No?
I don't think so. Steve?
Yes, if it's deductible by the husband, it's includable as income to the wife.
Income to the wife.
Yeah.
Well, certainly those figures bear out your opinion regarding women and the equitable divorce system here in the East.
Well, the New Jersey court felt that using census figures and other studies that had been done nationwide, that these figures were pretty much true for the nation as a whole. All those, at least, especially all those 41 states that have equitable distribution laws.
Okay. Leonard, what is a prenuptial agreement?
It's an agreement that someone usually enters into before they get married to determine what will happen in the event of their death or divorce.
And do you have a recommendation of people who are seeing each other and contemplate marriage, whether they should enter into such an agreement?
It depends. If you're dealing with an elderly couple who has each married before and has children who they have responsibilities toward,
You don't have to be elderly for that.
no, then certainly in that situation I do. I think you have a problem, however, with young couples. I don't think that you want to build into your marriage such a conscious, explicit understanding that it may end in divorce, though obviously people privately should be so advised. You're really almost charged with that responsibility. But for example, I did have someone once who came to me who wanted to put in his prenuptial agreement that in the event of their divorce, they would have joint custody. And I was suggesting to him, as I did, that you're really signaling far more than you want to here about your fears. And if you're not careful, you won't have to sign this agreement because there'll never be a divorce. So you have to have a balancing of common sense as to what is important to protect and what you're risking in trying to protect it.
What's your opinion on prenuptial agreements?
I think they're a good idea, and they're becoming much more common. We see a great deal of them now. They've always been somewhat common in second marriages, particularly late in life. But with equitable distribution and with the trend towards people wanting to either make the marriage an economic partnership or sharing it according to defined terms, they're more and more common, and I think it's a good idea.
Steve, however, here's a couple in love. Would you say, meet my mother, meet my father, meet my lawyer?
It's a problem, Alan. You know what happens when you draft these things and then you explain to a client, let's say it's the husband, this clause can be in there, that clause can be in there, and he takes it home, and he comes back, he says, eliminate that, eliminate that. So I said, well, that's what you wanted, but I love her, you know. And obviously there's a natural tendency to not do it, and it's still not the rule, but they're more common than what they have been in the past.
Catherine, I know you'd like to educate the court system, educate the judges. How would you go about that?
Well, partly that was one of my intentions in writing this article, was just to set up what some of the situations are that people are dealing with. I think, in particular, that judges are probably not aware of some of the problems that are specific to older women. I think that judges don't realize how difficult it is for a woman who's been out of the job market for 30 years, has raised 4 children, to suddenly try and get a job that will allow her to live in the standard of living that she's become accustomed to over those 30 years of marriage to a lawyer, say, or someone else in an income bracket that she couldn't possibly hope to aspire to.
Let me say this, if I may, Alan. The article has had a rather pervasive effect among judges, lawyers, and people involved in divorce and separation. And I think it will bring some of the problems that we're facing to the attention to the powers that be.
Leonard, how do you feel about what's going on here and mediation versus the adversary proceedings?
Well, obviously, I'm not a big fan of adversarial proceedings. As I always say, you know, lawyers can't complain if we accuse them of making adversaries of parties. They function in an adversarial setting. One of the things I'd like to point out, you asked me in terms of success ratios. I'm not going to tell you how successful I am personally or not, but one thing that I've noted that I'm very pleased with, I've done hundreds of mediations, and I've never once had a woman come to me and present me with a statement from a telephone company telling me they're going to disconnect her phone, or from a bank saying they're going to foreclose. Believe it or not, this simply does not happen in mediation. And yet when I was in private practice, it seemed to me that these were the kinds of brush fires I spent my life trying to put out and never doing it quite successfully. So from my standpoint, I'm able to spend more of my time addressing what really are the substantive issues rather than what seemed to have occurred from the process, that we were faced with all of these issues that didn't start out to be issues that the people had, but simply became issues because the adversarial process was not concluding the matter for them quickly enough.
Steve, I got a letter in, and I'm going to ask you the question that the viewer wrote in. She said she just inherited $5,000 from her father, and the marriage was on the rocks. But she was concerned. This was all the money she had, and she knew about equitable distribution, and she really didn't want to give out half of that or whatever percentage. What's the answer to that?
She doesn't have to, Alan. The concept of marital property is one that all property acquired during the marriage becomes marital property and subject to equitable distribution, with a couple of exceptions. One is property that's inherited. The other is, of course, property that's a gift from a third party or property from a personal injury claim or something like that.
Okay.
So she has no problem.
Catherine, we have a few minutes left. In conclusion, what would you like to tell our viewing audience?
Well, I think what I would like to tell people, one of the major criticisms I've gotten for this piece was that I presented such a depressing picture that women might not feel that they should go ahead and embark on a divorce. I would like to say if it's that bad and you think it's worth it, that you should go into it with your eyes open and know what your options are and know what the problems may be.
Leonard, in conclusion?
I don't want anyone to conclude that I have any disregard for matrimonial lawyers. I happen to think Steve is one of the most responsible, best lawyers I know. It's the system that I have some difficulty with, and I think that people really should be offered an alternative.
And Steve, in summation?
What struck a chord in Catherine's article are the stories about the spouse who knows virtually nothing about the financial structure of the marriage. And I think, if nothing else, you've woken some of these people up, and I think that's terribly important for people to be attuned to that. So if this does happen, they're equipped.
Thank you very much. Thank you. You've been listening to Steve Gassman, a matrimonial attorney, Catherine Booten, recent author of the article in New York Magazine, and Leonard Marlowe, mediation specialist. Thank you very much, and we hope that you tune in to Lawline next week.
You have been listening to Lawline with your host, New York lawyer Alan Schnerman. Mr. Schnerman will be back with you again next week at this same time.